Good afternoon, members. Welcome to the second session of the East Africa Law Society Annual Conference and General Assembly. My name is Barbara Maloa. I am your Deputy Secretary General, and I also sit in as the Young Lawyers Representative. I don't know, can you hear me? Can you hear me? Okay. First of all, let me take this time to thank all of you for logging in. We usually have our conference at the end of the year. This time round was supposed to go to Bujumbura, but because of the prevailing circumstances, it was not possible. And so the governing council passed a resolution to have the conference online. Our first session dealt with pro bono. And the second session, we are going to look at access to justice amidst the COVID-19 pandemic. You'll all agree with me, this year has been very trying for most, if not all of us.
They have allowed, have complained.
It's been very trying for all of us. Most sectors of the economy, various sectors of the economy have been tremendously affected, and the legal sector, and by extension, access to justice, has not been spared. The norm was, as practitioners, we were used to going to court, attending physical court sessions, filing our papers in court, but with the pandemic, things changed tremendously. We've now had to adapt to virtual court sessions, amongst other mechanisms of access to justice. This afternoon, we are joined by a panel of speakers, our first one being Honorable Ifnalis Okubo, who sits as the Registrar of the East African Courts of Justice, based in Arusha. Honorable Okubo is going to talk to us or have a presentation on access to justice in the East African community amidst the COVID-19. Courts across the region have responded to the COVID-19 pandemic by innovative and have had to quickly adapt to technology to dispense justice. The East African Courts of Justice hasn't been left out. To tell us more about the measures they've taken during this pandemic from when it began in March is the Registrar, the Honorable Ifnalis Okubo. I believe during the year we've had a number of sessions on how to file your matters at the East African Court of Justice during this period, and he's been very helpful. We've had a number of webinars. ELS has had a number of webinars on this particular topic, and we are honored and glad to have Honorable Ifnalis Okubo back here to give us a brief presentation on the same. I will hand it over to him at this point.
Good afternoon, ladies and gentlemen. It is unfortunate I can't be with you on the screen. I'm held up somewhere. However, I hope the short presentation which I've recorded is going to be helpful to everybody. Now, the East African Court of Justice, as you know, is the judicial arm of the community, established by Article 9 of the treaty as one of the organs of the community. The court, therefore, has the sole responsibility to deal with matters of interpretation of the treaty. Any violation of the treaty, if anybody has any question touching on the violation of the treaty, then the court has jurisdiction to determine that matter. Access to the courts or access to justice under East African Court of Justice is granted by several articles of the treaty and, of course, the rules of the court. Specifically, Rule 27, Article 27, Article 30, Article 23, and Article 35 that deals with appeals. For any resident, natural or legal person, to access the courts, all you need to satisfy the court is that you are a resident of the community or that the company is registered within the community. However, as you do that, under Article 30 Sub-Rule 2, you have to do that within 30 days of whatever act or action you are complaining about. Failure to do that, then you'll be locked out, you'll be out of time, and unfortunately, the treaty does not give room for extension of that period. It's also quite unfortunate that very many good cases have been lost because they did not follow the time limit specified in Article 30, Sub-Article 2. Now, one of the things we have tried to do to improve access to the courts is to come up with simplified rules of procedure. We have also created sub-registries in all our capitals, whereby if you want to fight a matter, you don't need to reach to Arusha, but you just proceed to the sub-registries, you'll have your matter filed there. These sub-registries are manned by staff of the courts who also understand the procedures of the courts and can therefore guide you when you want to file a matter. Besides that, we are now also going paperless. We have been doing test runs of our case management system. We did one test run particularly with the Tanzania-based lawyers, where you can file a matter from the comfort of your house, from the comfort of your car, from the comfort of your office. It will be as good as having walked to the sub-registry or having come to Arusha and filed your matter from there. That makes work a bit easier and it brings down the cost of litigation and also saves a lot of time. The procedures in our court are such that, in fact, you can file your matters, file all submissions, and just let the court decide from the documents you have filed without you uttering a word. So the applicant files the case, serves on the respondent files a reply, the applicant files a rejoinder if any, if not, then pleadings close after 14 days. And then after 14 days, you are invited to a scheduling conference, again, which you may not need to come to court if you can agree on the issues and the court agrees with the issues. After the scheduling conference, you can decide that the matter should be decided on documents only. So you'll file your submissions and all your authorities serve the other side, who will also respond in the same way. And then you wait for the court to give a ruling. Of course, the other alternative is to appear, where the lawyers will appear before the court for the hearing, conduct the hearing either through highlighting all the submissions they had written, or even by witness testifying before the court, after which the court will give a judgment. We have 6 judges in the first instance division, and the minimum quorum we require is 3. So we are in a position to hold 2 concurrent sessions for the first instance division. That will also make the disposal of cases a bit faster. Now the appellate division, there are 5, so they can sit 3 or 5 to hear an appeal. Another matter that I may wish to bring to your attention, and which most lawyers probably have never noticed. It has come to my notice that when I tell lawyers you can file matters to the EACJ, they always say they don't see those cases. But any violation by a government of its own laws, it is a violation of the treaty, particularly Article 6, D, and 7, Sub-Article 2. And if you look back in your national states, there are a lot of instances where your own governments have violated their own laws, which they made themselves. Those will be such good cases to come to court. Now, initially and for a long time, most of the cases that have been coming have been under Article 6 and Article 7. and mostly touching on violations of human rights. Of late, however, we have started receiving a lot of cases dealing with trade matters. There was a question at one time that this court was set up specifically to deal with the disputes involving trade. How comes it is dealing with more disputes involving human rights? But as you will notice, it will be difficult for you to deal with integration matters if your human rights matters have not been settled. And I believe it is for that reason that most litigants came first to court to clarify, to seek clarifications on matters of human rights violations before they can go into matters of integration. The court also has arbitral jurisdiction. Now, a lot of you deal with commercial contracts. This is where in that commercial contract, the dispute resolution provision, you can confer that power to conduct arbitration to the East African Court of Justice. And our judges will hear the matter as arbitrators, not as judges, but they have also been trained as arbitrators, and most of them are fellow arbitrators. So the issue of competency to handle arbitration, they are well skilled to do that. Besides that, mediation can also be undertaken in our courts, although it has not, we have never had an instance, but that can also be practiced. It is provided under our rules. Another issue that will be important to bring to your attention is that to file matters before the court, you don't need to exhaust local remedies. This is unique to the East African Court of Justice, unlike very many other international courts. And it is traced back to the issue of community being a people-centered, market-driven organization. So if you start putting or demanding that litigants exhaust local remedies, the first thing is that you will run foul with Article 32, because by the time they exhaust local remedies, then 2 months limitation period will have finished. Now, because it was created for the residents of the community, access had to be made easier. That then you don't need to exhaust local remedies, you come there straight. And the issue of local remedies, exhaustion of local remedies, has been challenged with very many decisions in the court, where the court ruled that for ESCJ's case, then you don't need to exhaust local remedies. But you must also be careful as to who you can bring to this court. It's not a court you can just sue anybody. So you can sue the Secretary General, you can sue an institution of the community, you can sue the Council of Ministers, you can sue the partner states, the Attorney Generals of the 6 partner states. Those are the only people you can bring to court. Article 38(2) also provides for execution of judgments, judgments of this court. This matter has also been raised very many times, where some lawyers have questioned the process of execution of judgments of the court. Others have complained the judgments of the court have not been obeyed. But Article 38(2) provides that every partner state shall take all the necessary steps to make sure they have complied with the decisions of the courts. That means if a judgment is passed against a partner state that does not comply with it, it will in itself be again a violation of the treaty, and that partner state can be brought back to court again by violating the treaty, Article 38(2). Another item that maybe I should bring forward to you is the appointment of judges, which is done by the summit on recommendation of every partner state. Unfortunately, we don't have an East African Community Judicial Service Commission that will vet the judges and appoint them. So every country nominates a name, which is brought to the summit, and the judge is appointed. Out of those judges appointed, one, of course, will be the president of the court. Then we'll have the vice president of the court. Another one will be the principal judge and the deputy principal judge. Now, the president and the principal judge have to be, or rather are, residents at the seat of the courts, unlike the other judges who come only when there are sessions. Now, the purpose of having the president and the principal judge being resident was to manage the affairs of the respective divisions while they are at the seat of the courts, of course in collaboration with the registrar. to make work a bit easier. But on the other hand, now we have the other sessions judges who only come when there are sessions. And that means sometimes it is difficult to have an urgent matter heard immediately. For example, one might file a case under certificate of urgency today, and the sessions of the court were ending that same day, or they're ending tomorrow. You find that such a matter may not be heard, yet it was filed under certificate, and getting these judges back may not be easy. Another problem, in fact, which you'll note that affects access to justice, is that you find that these judges, most of the judges at EACJ, are also judges back in their national judiciaries. So there is that dual loyalty back to the national judiciary and again at the regional courts. That sort of creates a problem, and it slows down sometimes conclusion of matters within a reasonable time. Our plea has been to have all judges live in Arusha or at the seat of the court. At least we succeeded for the president and the principal judge, and I hope very soon this matter is before ministers. It will be concluded and we'll have all judges sitting there. That of course will enhance access to justice if you take their presence there and the online system of working which we have adapted. Incidentally, last year when we were reviewing our rules, we included the rules for online use of technology in our dispensation of justice long before COVID came. So when COVID arrived, it found we were prepared. We have been holding court sessions since March through virtual online systems, and I'm sure some of you have participated in them. All we have noticed is that they have enhanced the way we work, they have enhanced dispensation of justice, and distance now does not matter. So that even if judges will be staying in Arusha, matters can still be conducted with the advocates from wherever they are, and judgments delivered in any normal way. Maybe the last point I need to mention about access to justice is that we don't have a register. We don't maintain a register for lawyers eligible to appear before EACJ. If you can be admitted as an advocate in your national jurisdiction today in the morning, and you get your practicing certificate in the afternoon, you can appear before EACJ. And I will encourage most lawyers to be exposed to this national litigation practice. It's very good and very encouraging. As I finish, I'd like to appeal to you to seriously look into the matters of amendments of the treaty to make access to justice better and for you and other residents of the community to enjoy the East African community. The treaty was last amended more than 10 years ago, only when there was a crisis. And I've been talking to other forums telling them maybe we need another crisis for the treaty to be amended. If you recall, the case of Anyang' Nyong'o is the one that led to the amendments of the treaty. One of the major reasons impeding access to justice is that 60 days limitation period, which is anchored in the treaty. Therefore, the court's hands are tied. They cannot extend that time. That is one area that clearly needs amendment. There's no other international court that has such a short limitation period. Another matter that you may want to also try and persuade that in the court, so that the treaty can be amended, is the issue of the term of the judges. The judges of ESJ are appointed for 7 years. That's the tenure, which is okay. But again, there's another rider, either 7 years or age 70. So we have two methods of exiting the court, which is not good. You find a judge is appointed, maybe 67. So you'll work for 3 years only and leave. Others who are lucky they're appointed, they still have that a lot of time, they do 7 years. It would be better if we had only one method of exit of the judges. If it is 7 years, it is 7 years. There's no retirement age. Once you do 7 years, you go. I hope this is sufficient information for today. We can discuss further. It's unfortunate, as I said earlier, I couldn't make it. I'm quite far and where also the systems are not very good. Thank you very much for listening.
Thank you so much to the registrar for that presentation in absentia. I think from the presentation, we've learned that the East Africa Courts of Justice was prepared. It's a court that in Arusha, so really it's difficult for most of us to travel down and appear before it physically. So I think they are pretty much prepared for the pandemic. Not that they planned for it, but they are prepared. The registrar has also mentioned that this the digital migration to use of the virtual court platforms has enhanced the way they look at their work. And also right now, as I've said before, distance does not matter. So maybe what we need to consider is look into amendment of treaties of the treaty. He has mentioned that it's very unfortunate that we had to be faced with this pandemic for us to realize the need for the amendment of the treaty. I'll move on to our second speaker of the day, who is Miss Faith Masharia from the Africa Legal Network and Anjawala and Kana. Faith is a partner at Anjawala and Kana, which is a leading law firm in the region. And I'll say at this point, Ellen are very supportive of all ELS activities, and I take this opportunity to thank you very much. Faith practices includes domestic, regional, and international representation of parties before different courts, tribunals, and other forums. She has handled a blend of complex matters as the lead lawyer and as part of a team before the East Africa Courts of Justice. All levels of courts in Kenya, several local tribunals and international tribunals appointed by the London Court of International Arbitration. The matters include complex commercial disputes, trade disputes, employment disputes, shareholders disputes, land disputes, amongst others. Faith is a co-author of the Kenyan chapter of the 7th and 8th editions of the International Arbitration Review. She's also a co-author of the Kenyan chapter of the Chambers of Anti-Corruption Global Practice Guide 2018. She also speaks as a panelist on arbitration topics in the region, including the 2016 East Africa International Arbitration Conference held in Kampala. Faith was ranked as an associate to watch in 2018 Chambers ranking in dispute resolution in Kenya. And clients acknowledge that she is very good. She has very good insights and is always on top of facts and strategy. And I think true to that, this year I believe in the Nairobi branch legal awards that are coming, Faith has been nominated as Best Lawyer of the Year and also People Master of the Year. Faith, thank you so much for agreeing to participate in this session. The floor is now open to you. Faith is going to speak to us on the various countries' adaptation responses to emerging access to justice needs in the context of the COVID-19 pandemic. You're welcome, Faith.
Thank you, Barbara. Thank you so much for the warm welcome. Good afternoon, members, friends, and all participants in this year East Africa Law Society Annual Conference, which took off earlier today. It's a great honor for me to make the opening remarks for this session. It is indeed a pleasure speaking to all of us today, and I look forward to the interactions that we'll have during this conference, albeit virtually under the current circumstances. As the program for today's afternoon session sets out, this session is going to cover the topic, access to justice, specifically considering various countries' adaptation responses to emerging access to justice needs in the context of COVID-19 pandemic. Now, if you take a quick glance of the report of the Task Force on Justice that's dated April 2019 on Justice for All, the Task Force on Justice reported that in total, this is globally, 5.1 billion people, 2/3 of the world's population, they lack meaningful access to justice. This is a huge number, you'll agree with me. This is data in the pre-COVID-19 pandemic confirming that the issue of access to justice pre-existed the COVID-19 pandemic. However, this statistic is likely to have gone up in the current climate. Now, the year 2020 took an unprecedented turn following the outbreak of the COVID-19 pandemic in Wuhan, China, and the resultant spread across the globe. In most jurisdictions, including our countries in the East African community, governments scrambled to take up immediate reactionary measures to contain the spread of the virus in the jurisdictions, as they quickly realized that the pandemic was going to be with us for some time, and indeed it has been with us for some time now. These measures included institution of lockdowns, full lockdowns, partial lockdowns, cessation of movement into and out of cities which were found to have recorded the largest exposure to COVID-19, and closure of international borders, just to name a few. Now, hit by the pandemic, some courts around the world, and indeed in our region, have been forced to close completely, while others have been temporarily reducing their workload by only dealing with essential, or if you like, high priority cases. The meaning of what constitutes an essential case has varied across jurisdictions. Now, by adopting the use of technology and prioritizing cases based on immediacy, many courts have been able to continue operating, thereby ensuring the right of access to justice in these urgent cases, albeit virtually. However, there are considerable concerns about the increased backlog of cases, lengthy waiting periods of court dates around the world and in the region. This is especially concerning where individuals are prevented from seeking appropriate remedies or to assert their fundamental rights, particularly the right to liberty by habeas corpus, for example, or where a prisoner is eligible for early release. Now, for instance, in Kenya, the first COVID case was confirmed on 13th of March 2020. And on March 2020, and on 15th March 2020, that is merely 2 days after, the judiciary issued directions suspending all court operations until an undeterminable future date. Suffice to report that at this point, courts in Kenya are continuing virtually. Now, similar cases observed in Uganda and in Rwanda. The first confirmed case was reported on 14th March 2020. Subsequently, the Federal Supreme Court of Rwanda directed that federal courts be partially closed with effect from 20th March 2020. Of course, most of these jurisdictions continue to review their positions with time. Now, with such closures and scaling down of courts and other quasi-judicial institutions being implemented in various EAC jurisdictions, two conflicting and yet important interests come into play, namely the obligation of the respective governments to protect the health and the well-being of its citizens by taking measures to contain the spread of and the ripple effects of the pandemic in the various jurisdictions, vis-a-vis upholding the right to access to justice for the citizens, for the residents of the EAC and the public at large. Now, certain groups have been disproportionately affected by court closures or the shift to online modes of delivery. Women, children, persons in asylum settings or detention centers, and persons with disabilities. They're already facing considerable challenges in asserting their rights. And these problems, in my view, they're likely to be even more intensified in the current climate. Access to justice, though being a wide legal concept, can be understood simply as the formal ability for a person to obtain a remedy through formal or informal institution of justice against grievances. It is a cardinal tenet of the constitutional principle of the rule of law, which has been codified in the Bill of Rights in all of the member states in the EAC and internationally ratified treaties and conventions. For example, the Convention on International Civil and Political Rights. It provides in part that all persons shall be equal before courts and tribunals and shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. I am of the view that issues of access to justice, they go beyond the many international instruments that we've signed on this area, the constitutional provisions in various EAC member states' constitution. They must be translated to real benefits of the residents, of the populace on the ground at the domestic and regional level. To this end, the governments, through the judiciaries in the various EAC partner states and across the globe, had an uphill task to quickly come up with innovative measures which will not only ensure that the courts and judicial and quasi-judicial institutions were back to operations without promoting the spread of the virus, but also to ensure access to justice was promoted in their respective jurisdictions. We have seen courts in the region and globally indeed embracing newer technology that support court services, and in some instances, while being mindful of the possible tech-related issues that can impact on justice objectives. However, the changes that were made across the court sector have not been uniform. This is because some jurisdictions operate modern courts, which could more efficiently leverage newer technologies, while in many places, courts continue to replicate approaches to litigation that have been present for decades or even centuries. In addition, responses to COVID-19 pandemics, they varied across jurisdictions and courts. As parts of the justice system experienced an increased workload, while others saw a reduction in demand. For example, there was an increased demand in the criminal justice sector to reconsider bail and remand arrangements so that where possible prisons populations could be reduced. This was the case in Kenya and many countries within the region, as well as an increased focus on issues of domestic violence and family arrangements, including a significant increase in the need for court orders relating to child custody. At the same time, there's been some decline in parts of the litigation system as economic activity decreased and takeovers, mergers, and new contractual arrangements were not a focus of activity. In the next few minutes, we will undertake a comparative analysis of the various adaptation measures across various jurisdictions in the globe, having taken to address emerging access to justice issues amidst the pandemic. These measures will showcase how access to justice, both within the ESC and globally, has shifted from primarily traditional, face-to-face approach to a digital approach, with technology being a primary stimulus towards this shift. Finally, while I note that there are various stakeholders in promoting the access of justice in ESC and globally, such as the police, non-governmental organizations, and professional organizations, the legal organization, medical organization, bankers association, this presentation will focus on measures courts and other alternative dispute resolution centers, for example, the arbitration centers, have taken to respond to the pandemic while ensuring that access to justice is promoted. I'll therefore pass back the baton to the moderator to lead us through the discussion. Thank you.
Thank you so much, Faith, for that. Before we come back to you, this juncture, I'd like to go to the next speaker, who is Maria Florencia Vigiad. I hope I've pronounced it correctly. Maria is currently a senior attorney at the Center for Justice and International Law. She's in charge of, amongst others, coordinating the Americas Network on Nationality and Statelessness. She also represents and defends victims from the United States, Caribbean, and Andean region using the Inter-American Human Rights System, IAHRS, before the Inter-American Courts of Justice and other international human rights bodies. She's a part of the team that develops political advocacy and media strategies to address the human rights violations in America. Maria is going to give a brief presentation on global experience on access to justice amidst the COVID-19. I think so far we've heard from how Kenya, basically the East African region, has adapted and the experience with the COVID-19. So Maria is here to give us a brief presentation on the global experience. Welcome, Maria.
Hello, good morning and good afternoon for you. For me, it's morning. Thank you so much for having me here. Can you hear me correctly? Yes?
Yes, we can.
Yes,
Great,
Maria, we
thank
can
you.
proceed.
Thank you for confirming. I was having a bit of troubles with my connection. So sorry, I will make a short presentation about the COVID situation in the Americas, well, in the inter-American system and how the inter-American system is working out this situation. But first of all, I will make a brief introduction about the Center for Justice and International Law. That is where I work. And then I will move forward to the inter-American system also with a brief introduction for those of you that don't know more about how it works and how we adapt to this current situation. So CEGIL is a regional organization that specializes in representing cases before the Inter-American system on a pro bono basis. It was created in 1991 and currently it represents around 40% of the cases that are before the Inter-American Court. And before the Inter-American Commission, I think it's a bit more, around 50% of the cases. We, as a regional organization, we litigate all the cases with national partners, and yeah, they provide with all the information and contacts about the context and the victims, and we provide all the strategic knowledge about the litigation on the Inter-American system. We have 4 offices. Right now I'm based in the headquarters in Washington, D.C. Previously, I worked for the Mesoamerica office that is based in Costa Rica. And we also have another office in Brazil and another one in Buenos Aires. And this is how we cover the whole region. Well, as I was mentioned to you before, we litigate many of the cases before the Inter-American system. And this means like on a variety of issues, life and physical integrity. Most of our cases are of like gross violations such as enforced disappearance, extrajudicial execution, torture, women's rights, due process, access to justice, migrants, many others. So moving really quickly to an introduction about the Inter-American system and human rights. The Inter-American system is comprised of 2 institutions, the Inter-American Commission and the Inter-American Court. The Inter-American Commission is based in Washington, D.C., and the Inter-American Court is based in San Jose, Costa Rica. Both institutions are formed of 7 members. The commission members can or cannot be lawyers. It's not a requirement for them. All of them are independent experts. They are elected by our General Assembly. And their terms are for 4 years and can be re-elected only 1 more time. The commission functions are more broad than the courts, as we will see, like when I move forward, specifically to the responses to the pandemic too. So they have the function to promote and respect human rights, prepare reports about human rights violations, and also to respond and to the individual petitions. This is the current composition of the court, of the commission, sorry. And there you can see all the nationalities of the commissioners. And you can see also that there are more women than men. It's the first time that we have such a representation of women of our region at the commission. So as I was mentioning to you before, the Inter-American Commission has these two big functions, the contentious jurisdiction and the monitoring mechanisms. And during the both of them have been like working, and they adapted to the virtual and webinar way that in which we are working right now. The contentious jurisdiction involves the individual complaints, the monitoring recommendations, and the precautionary measures, while the monitoring mechanism involves the resolutions that Commission can enact, such as the one that they enacted at the beginning of the pandemic, that is like a guideline for the states of the Americas on how to address the human rights situations in their countries. Press releases, public hearings, the reporters that we have, country reports, follow-up reports, and thematics report. The Inter-American Court of Human Rights is also like comprised of 7 members. All of them have to be attorneys. They are also elected by the General Assembly, but only by the members that ratify the American Convention. And they are elected for a period of 6 years and can be re-elected for 1 more period. This is the current composition of the court. As you can see, it's very, very different to the commission. We only have 1 woman, but we are very lucky that she's the president of the court. The Inter-American Court has more limited functions compared to the Commission. It has a contentious mechanism to resolve the individual cases that the Commission submits to the court, because the Commission is the only one that can submit a case to the court. That's a big difference between the African system and the Inter-American system. Also, the court can work all the provisional measures that the commission submit to the court, or that the representatives of the victims on a case that is under the supervision of the court submit. And the monitoring, the compliance monitoring group that we will talk more about now. Then they have the advisory function to interpret the American Convention and other human rights instruments, the press releases, and statements. This is a short mention for you to see the difference between our systems. I think like between the Inter-American system and the African system, the only difference that in mechanisms, of course, there are many differences in how they develop these mechanisms, is the way in which the compliance monitoring works. That in our system is the commission and the court, and you have an specific or institution to do it. So moving really quickly to the engagement with the Inter-American Commission during the pandemic. Well, in relation to the contentious jurisdiction, the Commission, at the beginning of the pandemic, the Commission decided to suspend all the deadlines on all the cases, precautionary measures, friendly settlements, but they did not stop to send all the communications to the parties on these procedures. Another important thing about how the Commission adapt to this situation is that they continue to submit cases to the court. In fact, I think up until now, they submit 19 cases in 2020 to the court. And they also continue with the bilateral working meetings. A good thing about this is that before the pandemic, we were already like working on webinars and Zoom meetings to to make the procedures a bit like quicker, because we have as maybe some of you know, a big backlog, and this is one of the main problems of our system. Also in the contentious jurisdiction at the Commission, we have the precautionary measures during the pandemics. Even if the organizations and civil societies request many precautionary measures, the Commission only granted 4 related to COVID situation. And the first of it was granted on July 17th. So it took them like a long time to grant these measures, and these can like talk more about the effective of the mechanism. And these precautionary measures are about indigenous population in Venezuela, the situation of detention of persons deprived of liberty. And there is also one precautionary measure about a person that was enforced disappeared in Buenos Aires during the pandemic, but unfortunately this person, I think 1 month ago, they found his body. And yeah, I think when the Commission granted the precautionary measures, after 2 weeks, the body was found. So yeah, this also, it took like around 5 or 6 months to the Commission to grant the precautionary measure. In relation to the monitoring mechanisms at the Inter-American Commission during the pandemic, well, at the beginning of the pandemic, the Commission issued a resolution, the 120 resolution, to provide the states with some guidelines on how to address the human rights situation in our region. It is, I mean, you can find it online, a very like complete guideline that present information about the state of emergency, freedoms, and then all the vulnerable groups, people with disability, migrants, women, LGBTI persons, children, indigenous population. Since March, I mean, since the pandemic began, they also issue many press releases, and one thing that they are like using very frequently right now is also their Twitter, to have these like rapid responses. They also create their SACROI, that is like a rapid and integrated response coordinated unit. It's not clear what this unit is like doing. Well, at least that's my opinion. And they put this web about COVID and all the resources that the Commission produced during these months. They also, I think right now they are having their 3rd period of public hearing online. And also in these periods of sessions, they are having like bilateral meetings with states and victims, also to work on the cases on precautionary measures. They also mentioned that they will have a special section on their annual report about COVID in each of the countries, and they are also producing a thematic report about the COVID situation. So this is all the, and of course they are having a lot and hosting a lot of webinars about the COVID situation. This is about the commission and about the court. Well, the first responses of the court were very unusual for the work of the court, but very good received. And I say very unusual because they did a lot of work that is not like the contentious jurisdiction usual work of the court. So they put together a virtual information center about COVID and human rights. They issue a statement about the COVID-19 that is quite similar to the commission, to the one of the to the resolution that the commission enacted. They also put an infographic about with all the decisions in which the court already decide about the right to health. So they put an infographic and like a booklet with all the jurisprudence about that, also about public order and use of force. And I think like 1 month ago, they also published like a booklet about restriction and suspension of human rights, because this has been a big issue in our region. So briefly to mention you about the contingent jurisdiction at the court, so I can then explain the how they respond to the pandemic. As I mentioned before, the commission is the only one that can submit a case to the court, is its decision. The factual framework of the case before the court is given by the merits report that the commission produce and submit to the court. When a case arrives to the court preliminarily analyzes all the files and annex and contacts the representatives, requests their powers of attorneys, and if everything is okay, the court provide us with 2 months to submit our brief to the court. Then the same happened with the state. They have 2 months to present their response to our brief and any preliminary objections that they might have. After that, we usually have 1 month to respond to the preliminary objections. And in normal times, what happened after that was that the court called for a hearing. And I say normal times because it's a faculty of the court to call for a hearing. They are not obliged to do it, but usually it's what happened in the past. And after that, the court issued a decision about the admissibility or inadmissibility of the case, and the admission of preliminary executions and the merits and remedy reports. So how did the court respond to the pandemic on the contentious jurisdiction? Well, at the beginning of the pandemic, the same as the commission, they suspend all the communication with the parties for 2 months, if I am not wrong. They continue to work, but they did not, and this is a difference between the court and the commission. The court didn't continue to send the communications to the parties in any process. During these 2 months, there were, of course, no public hearings on merits. On June, they have their first public hearings, but it was about an advisory opinion. And at least what they said is that they decided to move forward with a a public hearing on an advisory opinion, because it was easier. All the logistic, they didn't have to deal with like victims testimonies. The hearing on advisory opinions is very different. All the persons or organizations that want to participate, they have like brief moments to present their arguments, while the public hearings on a merit, it can take 1 or 2 days before the court. So at the beginning, they didn't know how to deal with it. However, last week and I think today and tomorrow, they are having hearings on merits report that are online and um, available for the public to to watch them. Unfortunately, we don't know up until when it's going to be in this way, that the court is going to have all the period of sessions, at least until June of next year is what they already mentioned to us. And another thing about the merits report during merits hearings during the pandemic, as I was mentioning to you before, since it's a faculty of the court to celebrate the public hearings, at the beginning they decided they will not have public hearings in all the cases before the court. But right now they find also a new alternative, that is to have like a diligence where they only hear the victim's testimony. It's a private sessions that it can take like one or 2 hours only. So they can have like guarantee the victims this space that sometimes in our region is the only opportunity victims have to have someone that is independent to hear what happened to them after many years. During this time, I think the court and us as victim representative, we have to be very creative. We found many difficulties and obstacles to produce testimony and other evidence to notarize the testimonies, and we are like in like informal conversations with the court also on how to solve these situations. And right now we are like working on each case by case. But the court was very open and flexible with this. So it's been hard, of course, to adapt to this new reality, but we are like working this out with the court, and yeah, in a good way. On the monitoring compliance procedure, well, a brief information about the procedure. Is mostly written, and how it works is that it's an exchange of reports. The states present a written report to the court on the status of compliance of the measures of reparations that were issued by the courts on the decision. And once the state issued that report, the court transferred that report to the commissions and the representative of the victims, and we have a period of time to present our observations. This procedure is private, except when the court issue a resolution on compliance or when the court decides to call for a hearing. But usually the monitoring compliance hearings have been private, at least in the last couple of years. Even if we requested many times that happened like in public. So how did the monitoring compliance work during the pandemic? Requested by civil society organizations, the court decided to have public hearings on provisional measures, on a case of migrant person, and also on a case of persons deprived of liberty. These were public. They also had other private hearings on other cases that are not related to COVID, but that the hearings were requested by the representatives of the victims a long time ago. The written procedure continue. It was a bit like late and delayed, but this is understandable. And the states in many occasions requested extensions based on the pandemic, and that for example, the judicial power was not working. So they have many different arguments. And up until now, the court issued 3 resolutions of compliance and provisional measures related to COVID. The 3 of them related to the conditions on of detention, people with pre-existing conditions and also COVID positive people that are detained. And this is all. Thank you so much for your time. I leave you this information here. We have a COVID website where we are putting together all the legal resources, not only produced by us, also by other civil society organizations, and also by the Commission and the Court. Thank you.
Thank you very much, Maria, for that presentation. It's very interesting to hear what other jurisdictions are doing out there. We can always learn and borrow a leaf. And in line with that, I would just like to bring back Ms. Faith Macharia to give a presentation on comparison within East Africa, on how the different regions, the different countries within the region have adapted to how the various countries have adapted to responding to the emerging access to justice in the context of COVID-19. Welcome back, Faith. And to members, sorry, Faith, before you continue, to members, I've seen some members have raised up their hands. Please save your questions for the plenary session, which will come in immediately after Faith. I've not ignored you. I've seen 2 of you, and if you have questions, please type them on the chat section. Thank you. Faith, please proceed.
Thank you, Barbara. We've just heard what some of the measures that the government in America has taken. And in this session, I'll quickly look at the measures that have been taken by the Kenyan justice system. And if time permitting, we can briefly look at some of the measures taken in other jurisdictions, for example, the UK and China. Now, to start us off and just to contextualize my presentation, I think it would be good for me to talk about the timeline of events. Because we had the first COVID case reported in Kenya sometime on the 13th March 2020. And immediately thereafter, we had the government of Kenya, taking up certain measures, putting in place social distancing measures, including, barring public gatherings, weddings, funerals, etc. Then we also saw the government announcing a state curfew. This was a dusk to dawn curfew, 7 p.m. to 5 a.m. effective. And this curfew has been extended several times, and the timelines, of course, have been reviewed. We also saw international flights being suspended from coming into the country, apart from cargo planes, of course, and those arriving to evacuate foreign nationals from Kenya. Also, the government suspended the entry of passenger ferries from our neighboring country, Tanzania, and Somalia, effectively closing its international borders with these 2 countries. And only cargo vehicles from Uganda, from Tanzania, for example, from Rwanda, they were permitted to enter Kenya on condition that the drivers of these trucks were submitted to mandatory COVID-19 testing and subsequently declared negative of the pandemic. Now, thereafter, we saw the National Council on Administration of Justice, which is composed of both state and non-state actors in Kenya, and of course headed by the Chief Justice of the Republic of Kenya. It was set up to assess issues relating to access to justice in the context of the pandemic. Now the NCAJ, they immediately sprung into action and they issued its first statement on 15th March 2020, in which they suspended all court sittings in Kenya except for urgent matters, as well as all foreign travels for judiciary staff. We also saw the suspension of transportation of prisoners from our prisons to the court to take the plea. Mentions were suspended, hearings were suspended a bit for a short time before the virtual hearings kicked in. Now, some of the challenges for these immediate measures is that priority was only given to matters which were deemed urgent, and it therefore resulted in an increase in the backlog of cases, as well as complaints of discrimination from the public, because those who were not able to demonstrate urgency in their matters, they were not able to gain access to the court system at the time. Then further, the daily curfew that I mentioned from dawn to dusk, it meant that persons are arrested close to those hours or even after those hours. They were not able to access legal representation in Kenya in contravention to their rights under the Constitution. Effectively, litigants felt that they were being denied access to justice and the rule of law was not being upheld at the time. Now, out of these concerns coming from the public, the Law Society of Kenya, they filed a constitutional petition at the High Court of Kenya, seeking, among other orders directing that access to justice be provided to the public without discrimination. The LSK further sought orders that legal services in this country be declared as essential services so that the common mwananchi could be able to access legal representation even beyond the curfew hours. Now, the court ruled in favor of the Law Society of Kenya, and the net result was thereafter, we saw a significant increase in the number of court sessions, tribunal hearings, and also the judiciary thereafter. They rolled out further measures and directions to facilitate access to justice. We'll be looking at some of these measures. You'll also be pleased to know that the High Court of Kenya also made an order declaring legal services in Kenya as an essential service. Now, some of the measures that have been taken in regard to civil suits, of course, we're talking about introduction of virtual courts. This was seen by the integration of Microsoft Teams to all judges in Kenya, magistrate chambers, to be able to proceed with virtual courtrooms. Now, this links to each of the judges and the magistrates. Virtual courtrooms, they're provided in daily course list, and they're posted on Kenya Law Report website. Now, this website is available to all Kenyans or members of the public, and to access the website is free of charge. Now, this is a critical, an important point towards ensuring access to open justice, because justice must be seen to be done, not only to be done, but it must be done. Now, open court hearing, if you may, our court reporters, for example, or our newspapers reporters, they're able to access the court links from the Kenya Law Report website. They're able to join courts, but of course they don't participate in the proceedings. But most importantly, they're able to report back to the public on key decisions or key developments that are coming from the judiciary. As a country, I think this is a step towards the right direction, as some countries are still debating on how to ensure access to open justice. Now, further, we have these recordings that are done virtually. They are recorded. I mean, they record a true account to show what happened in court. I frequent our courts at different levels and several tribunals, and as much as we have a few tech challenges here and there, largely, in my view, the system is working. Notably, the Supreme Court and the Court of Appeal in Kenya, they are fully digital, and all proceedings and hearings, they're now being conducted virtually. We also saw the launch of the judiciary e-filing portal. I know in other jurisdictions like the UK, they're already doing this, but this was launched after the pandemic in Kenya. This basically meant that now the litigants in Kenya, they were able to file their pleadings. They were able to assess how much they're going to pay for the filing of the pleadings while seated in their office. They were able to pay for these fees, and they were able to file the court pleadings from the comfort of their office, of their home, or wherever they were working from. Again, just to facilitate this process, the judiciary shared contact lists, and which was updated from time to time. This included email addresses, telephone numbers of court stations, and specific contact persons for each court stations. These were posted on Kenya Law Report so that members of the public as well, they could be able to access this. Now, for the stakeholders, they were given directions as to the filing of matters under certificate of urgency and the filing of time-bound pleadings. Then also the judiciary ensured that there is a duty judge in each of the superior courts and the magistrate of courts in every station to deal with urgent instructions, so that when you file your certificate of urgency online, we have a duty judge or a duty magistrate who's able to give directions on your application, and the directions are sent back to you on email. I mean, in my view, this has greatly expedited the speed in which the matters are filed, because in the past, the filing system in our country specifically was not one of the best. It could take hours, for example, because of human traffic, to have their pleading assessed, then go to the bank, for example, to pay and come back for payment. That whole process has been, made easier at this point. Now, the other thing that we've actually seen is expedited delivery of judgments and rulings. Now, following the guidelines that were issued by the National Emergency Response Committee on Coronavirus, to judges and magistrates, they started executing their duties immediately from home. Remember, I said initially the court system was closed. So during that period, our magistrates and judges, they were executing their duties from home in the first few weeks after the first COVID case was reported in Kenya. Now, out of this, we saw the Supreme Court delivering 10 rulings. The Court of Appeal was able to deliver 45 judgments and rulings of appeals and applications of courts. Then we had the High Court delivering 367 judgments and rulings. We had the Environment and Land Court delivering 267 rulings. The Employment and Labor Relations Court 75, and the subordinate courts in general, about 390 rulings. We are seeing this within a week of merely 2 to 3 weeks after the National Emergency Response Committee gave directions on COVID-19. And then we've also seen that various heads of courts and tribunals in Kenya, they've issued directions of delivery of judgments and rulings in cases of where parties or advocates had not provided their email address. So we've seen the continuation of the justice system virtually as we speak. Now, what about execution proceedings? Because these are important. You've had all the delivery of the many number of rulings and judgments. How do you execute them? What are the directions of execution during this pandemic? Now, immediately after the announcements, the first announcement of the confirmation of COVID-19 case in Kenya, this was way back in March 15, 2020, the court temporarily suspended the execution of judgments. So we had the bailiffs, the police and the questionnaires, they were instructed not to carry out execution of warrants, orders, decrees issued before 15th of March 2020. But the orders and directives of a conservative nature and mandatory injunctions that were issued prior to this period, they were, however, able to be executed. However, following the rapid increase in the number of judgments that I have mentioned, and the suspension of execution was lifted on 2nd of June, a few months later, when the Chief Justice issued a statement directing all courts to resume and facilitate the extraction and issuance of orders and decrees. So as we're speaking now, you're able to get your judgment and you're able to execute your decree in the normal course. Now, let's quickly look at some of the measures that were taken in respect to our criminal system or the criminal suits. Of course, there was also the introduction of virtual hearing in criminal matters, particularly with respect that the prisoners do not get infected with the virus while in the courtrooms. Also, in respect to detention of arrested persons, We saw directions issued that police bond, petty and traffic offenders should not be held at police station for more than 24 hours. They were supposed to be released on cash bail or free police bond. And then officers in charge of police station, they were under strict instructions to implement these directions. And basically this was to prevent the spread of the virus from arrested person who may have been infected by the virus to inmates. Now, to enhance transparency and accountability of this process, we had the National Police Service establishing a centralized records showing basically the number of people that have been arrested, cases that have been handled in all police stations, and the terms of release on bail or bonds, if any. And also now we had the Director of Public Prosecution and submitting periodic reports to the National Council on Administration of Justice. This was a good measure in my view, as previously individuals in remand would be detained for months, well, even some years before they were arraigned in court. Now, going to decongestion of prisons. Now, in the last 2 weeks of March 2020, files of inmates who were petty offenders, jailed for less than 6 months, and others who had less than 6 months to complete their jail terms, they were presented to the High Court for review of their sentences. Subsequently, we saw about 4,800 inmates significantly released, and this was a significant decongestion of our prisons, and this process is continuous today. Now we have new inmates. They're being isolated to reduce the risk of infection, and movements of inmates was highly restricted. Also, prison visits, they were suspended, including visits to the staff quarters during this period. Now, if you look at the arbitration measures that have been taken, and I'm speaking in respect to the Nairobi Center for International Arbitration based in Nairobi, Kenya, we saw the NCIA issue a guidance note on the use of its facilities in Nairobi, so that how will you go about booking the facilities, the conditions, and the use of the facilities during the COVID-19 period, and basically encouraging parties to arbitration to utilize virtual hearing, and was able to offer its virtual facilities in hosting events such as targeted virtual trainings, online conferences, and workshops, as well as other capacity building initiatives. Now, the measures that we've actually seen, they've not come without challenges. And now let's just look at some of the challenges that we have faced in coming up with these measures. The first in mind is lack of adequate funding. And in order to provide the quality and accessible virtual system, the governments need to fund the judiciary. It has been difficult for the judiciary in Kenya, especially because of the reduced budget in the late 2019. But we saw judiciary taking innovative steps to ensure access to justice was maintained. The extent to which these measures could be implemented, however, in each of the 44 counties in the country was somehow inhibited because of the limited funds. We also saw a perceived sense of discrimination or denial of justice, even may, from the public. And this is following the scaling down of the judiciary staff and priority being given to applications that the court deemed to be urgent. The immediate result was that those that were not able to demonstrate urgency of their cases, they were not able to access the court system. And the net effect was that litigants felt that they were being denied access to justice, as a decision on whether a matter is urgent or not rests with a single person, without having the opportunity, as compared in the past, where you could appear before a judge and maybe argue the urgency of your matter. Now you don't have that opportunity to demonstrate the urgency in perspective. We've also seen inordinate delays, talking about delay in hearing maybe certificates of applications. Now, while we are able to quickly file applications of certificate of urgency through the online portal, there's been a notable delay in the determination of this certificate of urgency, which will normally be reviewed within the same day of filing or the next morning the period before the virtual system. Currently, the certificate of urgency, and I'm talking about practical experiences, they can even take up to a week. So you're able to file it very fast, within hours, for example. But now the judiciary has been lagging its legs, coming back to the litigants with directions of interim orders. And at times it can fit the entire purpose. If you're going for an injunction, for example, to stop a sale of a property, and you have to wait for a week before you get the directions, then before you get the directions a week later, it could be that the property has already been sold. So you also saw issues, there are also challenges in regard to the directions that were issued by the government clashing with other government measures. For example, the daily imposed curfew, so that arrested persons will therefore not be able to get assistance from legal counsel, as no one in this country will dare go, even the advocates, they do want to go out of the court, or they do want to go outside during the curfew hours, because the consequences were there. So these are some of the challenges that I think are coming up. And of course, there's the lack of internet access and connectivity in rural areas. In urban areas in Nairobi, the connectivity is fantastic. That is not the same case in our rural areas. There's digital illiteracy, especially among the senior population in our country. And also there's a resistance from some of the advocates. I don't want to call them archaic, but I'm really tempted to call them as such, to embrace technology. So we've also seen a bit of resistance by some of the advocates to embrace technology. Now, these are some of the measures that we've taken into the country. So maybe we can quickly look at what other jurisdictions are doing to address the issue of access to justice during these unprecedented times. So let's look about China. China is the most utilized, has the most utilized court system in the world. And it has implemented information and communication technology as central to its recent judicial reforms. They have internet courts, for example, and then they continue promoting the existing of virtual court filing and hearing system as they've done before. And we've also seen the Zhencheng High Court, People's Court in China, establishing a comprehensive online platform to provide parties with online access to services with no need to turn up in court for case filing. And this platform also accommodates online hearings, video conference hearings, after parties log in with a trial code assigned to them. So parties are given a trial code, and during your time you log in and access the court. Now, according to the Supreme Court of China, during 3rd February 2020 to about 30th April 2020, there were about 5.5 million cases that were filed across the country. That's a huge number. And among those, 1/4 of those cases, they were e-lodged. They were lodged electronically. And up to 24%, and this was about up to 24% compared with the same period of 2019. Now further, 16% of this 1.5 million hearings during this time, they were conducted remotely. And this was seen as a big increase compared with the same period in 2019 in terms of numbers that were seen, in terms of numbers of cases that were determined during such a period. Now, we've also seen they've taken actions for promoting justice by use of justice mobile applications. And this is just to address, concerns or interests of the younger population. So they have web-based platforms, and the Chinese court has previously developed justice application apps, and particularly for the young who are used to using their mobile phones to carry out various activities. So for example, the Supreme Court has developed a mobile micro court app, and they have rolled out to all courts in the country since August 2018. So this is not even after the pandemic period. So this app, which is a mobile app, it supports users to carry out online filing from your mobile, remote trial from your mobile, online evidence exchange from your mobile, and other related litigation functions from your mobile. So according to the Supreme Court of China, during the pandemic, and by 31st March 2020, the total user of this mobile micro court had reached the population of 1.39 million. and then they were reported 390,000 new users in March alone, representing a growth of about 86% compared to February. So, I mean, that's just a challenge to our tech people. Do you think maybe this is something that can be lodged in Kenya and in the East African region? Maybe that's food for thought. So the Chinese government has also lodged another application. It's a mobile court app, which can be downloaded on WeChat. WeChat is China's most popular social media form. So it's maybe, I don't know, what you can compare with back here. So you're able to go there and download this mobile court. You use this mobile court app. So you use facial recognition technology to authenticate the parties, the evidence, and the messages. Then they're directly uploaded on the app. And the Beijing Internet Courts have developed bots, basically to help determine hearing outcomes. So we are seeing non-human judges, which are powered by artificial intelligence, now determining cases. So this is no longer in the movies. It's actually happening in China. We can have discussions about whether we are compromising certain aspects of the justice system or even human rights on these artificial bots, non-human powered judges, powered by intelligence, determining cases. Now, what about the United Kingdom? So I'll just talk about the LCI, the London Court of International Arbitration Measures. This is a forum that I frequent, again, as was read out during my introduction. So we've seen the LCIA endorsing electronic communication as a primary form of communication. So, and this has been done formally. So they've actually specifically amended their rules to allow this. So initially the process was, you are required to serve a request of arbitration through email. And then it was mandatory for you to serve by courier or by postage, your opponent, the pleadings by hard copies of the pleadings. So this is no longer the case. So the primary communication, the primary way is by email. So once you've served your request for arbitration or your response, as the case may be, on email, then you don't have to serve again by hard copies. This is faster, this is time saving, and also this is cost saving aspect of it. Now, and the beauty of it is that this requirement of endorsing electronic communication as a primary form of communication, it actually extends to arbitral awards. And now parties are not forced to wait for original copies of the award to be couriered. The practice is, you used to get a notification that the award is ready, you're not given an advance copy, and you have to wait. You can imagine the pain if maybe, the client, it's a business, you have conned out of a business, you want to know your fate. So you've been told that your award was delivered on 5th of March, for example, and you have to wait again for a certain amount of time before you can receive the hard copy of the arbitral award for you to know the outcome of the case. So this is no longer the position, and now the arbitrators will be able to communicate the outcome of the award through email. Now, another important aspect that I want to mention in passing is about virtual hearings. So under the LCA rules, the tribunal initially had the discretion to determine the mode in which arbitral hearing will be conducted, of course, taking into account geographical location of parties and the cost of having the arbitration of the UK, so that it was possible to have the geographical seats of the arbitration outside of the UK. For example, we did an arbitration last year. So of course the applicable law was the law of England. The arbitral seat was in London, but parties, of course, with the consent of the LCA, we agreed to shift the geographical seat to Nairobi. So initially they were allowed to do that. However, parties in this process, parties were allowed to object to a proposed method of hearing with sufficient justification, as it were. Now, looking at the LCIA rules 2020, it's arguable that the door closes the window for to objections to virtual hearings, provided, of course, there is no impediment and applicable procedural rules or in the parties' arbitration agreement. So looking at Article 19.2 specifically, it provides that a hearing may take place in person or virtually by conference call, video conference, or using other communications technology with participants in one or more geographical places or in a combined form where then you have a hybrid sort of. Now, this has therefore allowed arbitrations to continue, particularly during this period. We actually engaged currently in an arbitration, and we continue to do the arbitration online when the UK has suspended travel into and out of the country. So those are some of the observations that I like to share at this point. So thank you, Barbara.
Thank you. Thank you very much, Faith. That was a very, very insightful presentation. So much to learn, especially from the likes of China on the mobile applications and UK as well. And also, I think you've managed to briefly but understandably so, explain the measures Kenya put in place during the pandemic. With that, and at this juncture, I'd like to bring in two of our panelists who are from Tanzania and Burundi. First, I'll introduce Mr. Patrick Didier Nkuri. Patrick is an advocate and lecturer from Burundi. He's an advocate and yes, he's a lecturer of law in Bujumbura. He's a senior partner at Burundi Legal Space Law Firm, BLS Nkuri and Company Advocates, and he also serves as the SG of the Burundi Bar Association. Patrick. I'd also like to introduce Fulgence Masawe. Fulgence Masawe is an advocate from the High Court of Tanzania and currently serves in the Directorate of Advocacy and Reforms at the Legal and Human Rights Center in Tanzania. Fulgence, please unmute.
Yes, I'm here.
Welcome, Fulgence. Just taking the discussion back to what Faith presented. I saw you practice in Tanzania. Your president, the Honorable John Pombe Magufuli, has denied on several occasions the existence of the pandemic. With regard to that, how was the court operating, or how has the court been operating in Tanzania, basically? Have you taken any measures in terms of access to justice, or has it been business as usual?
Thank you, Barbara. I know that the COVID-19 hasn't spared anyone, whether you deny it or you accept if there is a problem. Problem is there. We are not so special to say that, or we are less a human or more than a human to say that we are not affected by this pandemic. But for sure, Tanzania has a unique experience as far as COVID-19 pandemic is concerned. Tanzania state official declared the country COVID-free May 2020, having previously Steve D and any independent data or scrutiny, including WHO data on COVID-19. So technically, nothing much which was happening in Tanzania as far as COVID-19 is concerned. So the business is as usual, but we have seen some of the areas where we have seen some of the state organs or state agencies taking their own precaution or their own measures, which are not basically the government at the government level. But in our experience, what we have seen, for example, we have seen now, there was time that the court was trying to do video conference and virtual hearing of some of the cases. And there was time they were encouraging to do online filing of the documents for civil cases. Of course, it was introduced before the COVID-19, but it's not popular. But they are at the peak of the COVID-19 here, they were encouraging people to do online filing, but not many people who are aware of that system. And on the part of the criminal, cases, that's where we have seen a lot of shift. And the shift has been there to date. First of all, they suspended, the prison authorities suspended all the visits in the country. So no one was allowed to visit in prisons indefinitely from March 19th. The ban included prisoners, relatives, lawyers, and they were denied access to them at all. Even the legal counsel, they were not allowed to visit their clients in prison or in pre-trial detentions. So what happened ever since that there was no any communication between lawyers and their clients. And at the same time, the whole cases, criminal cases were conducted virtually. And to date, where there is no hearing, the full hearing where the witnesses are parading before the court, there is no any physical court attendance for those who are planning for court for the mentions. All the cases are conducted visually, that the inmates or the prisoners or the detainees or remandees, they remain at the prison and they are linked with the court through video conferences and with their lawyers. And it was later, there was some relaxation of these restrictions. In 1st of August this year is when they allow now lawyers, they can visit their clients at the prisons, but with a very restrictive measure. So it doesn't be easy. And for those who are in remand, they used to receive their relatives who are serving them food, so whatever, paying visit every day. But now they are not allowed to visit at all. So it is the prison department now who are dealing with food and everything. We know, according to Tanzania, that any remand prisoner, there is no any food which is available for them. It's a duty of the family members or the relatives. So what they are doing now, you have to pay to deposit money at the cafeteria, at the prison. Is the one who is responsible to give them food, save for the weekends on Saturdays and Sunday is when you are allowed to visit them, just to give them their necessaries of life like soaps and some other things when they are run out of it. But on the part of the president, Tanzania, just like any other country, prisons are overcrowded, and most of the numbers of the people in the prison are those on pre-trial detentions. There are people waiting for their cases to be heard. So on April 25th, President Magufuli pardoned almost 3,717 prisoners, in line with the recommendation which was made by WHO to decongest prisons and limit the spread of the disease. So those who were serving short-term sentences, they benefited this lenience from this clemency from the president, and this came in line with the commemoration of the Union of Tanzania mainland and Zanzibar, which is 26 April. So on this day, President is when he gave the clemency for, they were pardoned 3,717 prisoners. So that's to decongest. So apart from those, like you conducting video conferences and deny access to the prison and the pre-trial detention centers and the pardon which was given to prisoners, nothing much has been done to show that we have responded fully to the COVID-19 as far as access to justice is concerned. But we have seen the effect which we think that it is ongoing, that these prisoners or pre-trial detention facilities where these people are held, they don't have that freedom which they used to have before, like visiting courtrooms, they are not allowed anymore, only for emergency matters and hearing, the full hearing. So you know that they are not allowed to come out of the prison at all. So everything is conducted through video conferencing. So the only challenge I see, which is a denial to the access to justice, our technology hasn't to be that much friendly, and there are very few courts which can accommodate this service of video conferences. Like here in Dar es Salaam, there is only one court called the Kisutu, which is the resident magistrate court of Dar es Salaam, is only where they can conduct these video conferences. So all magistrates, which they have cases, they know that the accused want to be arraigned in court, they have to parade to go there just to line up all of them just to conduct their cases there. So it has been some kind of challenges for because we don't have enough facilities and only few they can connect sometimes. Sometimes there is a technological hiccup so that not always when you go to court that you can get access or you can get the hearing or the mention which or necessary orders which you are expecting, because sometimes they can't connect you, or sometimes they can say there's no electricity or there is a connectivity problem or technical problem. There is always those some kind of excuse. So there is no assurance that we are going to conduct this case through video conferences. That's why when it comes to hearing and the witnesses, they've opted to bring them physically to court. But for other necessary orders and mention which are coming, they don't bother bringing this accused person to court. They just appear through video conference. If it works, it will go. If it doesn't work, that's the end of business. So that is the experience for Tanzania. But in Tanzania, it's like when you talk about COVID-19, it is like committing, so what a serious political crime I can say. Yeah, so COVID-19, it has been something which you cannot talk about, and when you talk about it, you'll be seen as a enemy of the state, and they don't give room at all for anyone to entertain anything to do COVID-19. So if judges or magistrates, they've opted their own measures to take care of themselves and those around them, whatever they are doing it in their own initiatives. Yeah, so that's what is happening in Tanzania, and nothing much as far as COVID-19 is concerned, apart from this access to justice, which has been some challenges. Thank you, Bob.
Thank you so much, Mr. Masawe. Uh, Unfortunately, Mr. Patrick is not online, so I'll proceed to ask a question to Maria. Maria, are you still there?
Yes, I'm here.
Yes, Maria. During Faith's presentation, when addressing how China has responded to the COVID-19 pandemic, she spoke of the promotion of the use of Justice mobile application and the use of facial recognition technology. I'd like you to comment on that. And is the same being used in America, or any such similar measures adopted?
Well, we are just like beginning an investigation, like a research on that. Like, I don't think we have something like similar like that. But I know that like, for example, in Colombia, the government launched a program that you can see, like track where like people with COVID is, these kind of things, but not like with facial recognition. And I know there have been like a couple of like legal challenges to this program at the national level. I don't recall that the commission issue any statement about this. However, during the pandemic, there have been at least two big repressions and social protests, one in Colombia in September and one in Peru last week or 2 weeks ago. And it came to the commission's attention that the police and the government was using like social media to monitor where the protesters were, what kind of clothes they were using, and they like abusively detain these people using these techniques. But it's really like, it's something that is not like being regulated at the inter-American system, not at the national spheres. So it's kind of something that is under development. And that I think like the Commission and civil society, we are both like working on that. Like, I mean, we already saw that like as an issue and a problem right now, but nothing else has been developed.
Thanks, Maria. There's a hand raised. Nzovu Job. Are you still online? You had a question? Nzovu Job? Okay. There's a question from Ikoha Muhindi. And the question is to the registrar, who unfortunately is not with us. He asks how many arbitration matters have currently been filed and determined by the East Africa Court of Justice. Mr. Masawe, you practice in Arusha? Could you have Dar es Salaam, sorry.
Yes.
Would you be able to assist with that question, or would you know or have a rough idea or estimate?
No, I don't know much about arbitrations to be conducted by East African Court of Justice, but it's more or less of the trials which we always attend. But for the arbitration which they've been referred by the registrar, I'm not very much aware of that.
Thank you, Mr. Masawe. We'll.
I could assist.
Yes, Bwana CEO.
This is Hannington here. So far, yeah, indeed, we were having the discussion regarding the arbitration jurisdiction of the East African Court of Justice just at the recently concluded a Chartered Institute Arbitration Conference. And one of the things that came out is the fact that the ESCJ arbitration jurisdiction has not been properly utilized. And only one case has been taken to conclusion, and that was a case concerning East African Law Society years back. Other cases that have come before the court have been settled before, being canvassed on their merit. And probably that is one area that as a society and as the legal profession will have to work on to encourage the use of the arbitration jurisdiction of the East African Court of Justice. Thank you.
Thank you, Amol. I'm seeing Nzovu is back on. Do you want to ask a question? Nzovu Job? Okay. Going back to Faith, and even as we wind up, Faith?
Yes, Barbara, I can hear you.
Yes, okay, Faith. Yes. When addressing the challenges Kenyans face, or even the legal profession, you talked of digital literacy and resistance from, you didn't want to use the name, but archaic advocates to embrace technology. Now, with regard to these non-human judges powered by intelligence powering cases, do you think a country of ours, given this archaic advocates you have, do you think it's something, an approach would be willing to consider, or do you see us going that way in years to come?
Wow, Barbara, that's a very tricky question, but this is the way we look at it. Mm-hmm. So if we had discussions with Kenyan advocates at the time, right, before the pandemic about, having virtual hearings, and I believe maybe this could have been the discussions along the globe, transferring our entire hearing system, so to speak, from the face-to-face traditional sort of hearing to virtually, they will have told you it was impossible, okay? But because of the pandemic, it has forced us to change, and here we are. So based on that, I'll actually say it's a matter of time. So, and if we have to adopt, if we are actually forced with the situation to adopt to the changes, then we'll have no option to adopt. It's either you conform to what is happening, or you'll be left out, you'll be shut out. But then again, I think an important aspect to comment, and also this goes back to the question that you posed to my colleague from Dar es Salaam about measures being adopted in different countries and comparing what the Chinese government is doing in the courts in China. I think we also need to bear in mind that when looking at what other jurisdictions are doing and trying to import such solutions at home, which is good, but we have to do such with the necessary modifications and alterations. Now, for example, I talked about special codes in China, sort of restricted access to courts in China. That would be a bit tricky in a country like ours, where it's a constitutional mandate to provide, open access to justice. But nonetheless, we can actually say in some instances, maybe you can use special codes, maybe for those special matters, children matters, private matters, just to limit then access to the people that are specifically required to that case. So my point being, so even if you're looking to adopt these strategies, then we have to adopt it relevant to our use at home, and of course, looking at our laws and the provisions specifically of the constitutions in our countries.
Thank you so much, Faith, for that. At this point, I'd like to close this session, and if any of the panelists have any parting shot. Faith, do you have any closing remarks? Anything you'd like to say?
No, Barbara, thank you. Been a pleasure being a member of this panel.
Thank you so much. Maria?
No, thank you so much for the invitation. I learned so much about other jurisdictions. Thank you.
Thank you. Mr. Basawe from Dar es Salaam?
Yeah, Barbara, I don't have anything to add, and thank you for your time and consider me in your team.
Thank you. From me, mine is to thank all the panelists. Thank you for taking your time to prepare your presentations. I believe I speak for all the attendees when I say we've truly learned a lot, and we continue to learn and even try and borrow from other jurisdictions as we go along. Initially, I think a lot of people they didn't want to embrace technology, but with the pandemic, we were forced to adjust and adapt. So thank you so much for taking your time. To the Secretariat, thank you for organizing this session. I believe it has been very seamless. We continue tomorrow with the third session. I think the third session tomorrow will be on revisiting the East African Community Common Market Protocol, and we'll be joined by various experts. David Ochieng, he's a member of parliament in Kenya. He's a regional integration expert. Edwin Tabaro from Uganda. He's a former member of the governing council. And Francis Gimara as well as Patricia Muchiso. The conference, today was the first day of the conference. It runs all the way to Thursday. So I would encourage members to continue logging in. The same, we'll use the same login credentials throughout from today until Tuesday. Tomorrow we begin at midday. But login starts at 11:30. Thank you so much for your time.